Hi guys, welcome to Commercial Law Tutorials. Under the topic Law of Contract, we have already covered the definition, formation and the essentials of a valid contract. Offer and acceptance, advertisements, and now we are moving on to valid, void and voidable contracts. In this lesson, we will look at valid contracts, void contracts, and voidable contracts. We will also look at the factors which make a contract voidable and the remedies which are available when a contract is voidable. And at the end of the lesson, I'm going to give you popular exam questions relating to this lesson. First of all, valid contract. A valid contract is a legally binding promise made between parties to fulfill an obligation in exchange for something. A valid contract is a contractual agreement which is binding and enforceable. In a valid contract, all the parties are legally bound to perform according to all terms in the contract. Otherwise, there will be breach of contract. There are important elements that are set out for a contract to be considered to be valid. We have agreement. Parties should understand and agree with all the terms in the contract for it to be valid. There should be serious intention to contract. Parties should be seriously involved in the contract. Each party in the contract should be willing to perform according to the terms set out in that contract. Agreement must not be vague. Agreement must be clear. Contractual capacity of parties involved in a contract are also considered. Some persons have limited capacity to contract, for example, minors, insane, and the insolvent. Then we have lawfulness or legality of a contract. Contract should be lawful, that is, it should not be illegal. For example, contracts for murder. Then prescribed formalities which should be followed for certain contracts. Contracts that must be registered should be registered for those contracts to be valid. That is our example. Then we have possibility of performance. Performance should be possible in the contract. For example, sale of public properties like street lights and roads are void. Now, void contracts. A void contract is a formal contractual agreement that is invalid, illegitimate, and unenforceable from the moment it is created. Void contracts are unenforceable starting from the time they are created. Void contracts are null and cannot be ratified. A contract is made void by the absence of one or more of the essential elements of a valid contract we have just said before. That is, if there is no agreement between the parties, that contract is void. If parties have no serious intention to contract, if they lack the seriousness in the contract, that contract is also void. If the agreement is not clear, the terms when they are vague, the contract is void. And where contract is entered into by people with limited capacity to contract, that contract is also void. If it is an illegal contract or an unlawful contract, that contract is also void. And Where prescribed formalities have not been followed for particular contracts, they are also considered void contracts. And where performance is just impossible, the contracts are also void. Now, voidable contracts. A voidable contract is a contract that is valid but can be declared invalid at the request of one of the parties because of a defect in how it was made. Assuming that all the essentials of a contract are present in the agreement, there may nevertheless be some cause or reason or flaw or defect which existed before or at the time of the agreement, which entitles one of the parties to cancel the contract and to claim that both parties be restored where possible to their original position. There are factors which render a contract voidable. These are duress, undue influence, mistake, and misrepresentation. So from the beginning, contract is valid and is binding on the parties, and it remains so unless and until it is justifiably cancelled by the affected party. The affected party must decide on what to do with the contract within a reasonable time after knowledge of the defect in his consent, and having made his choice, he cannot change his mind. Such party is put to an election either to affirm the contract, that is to uphold it, or to rescind it, that is to cancel it. If he chooses to affirm the contract, he is bound by all the terms set out in that contract. He has to follow all the terms and he has to deliver in that contract. But if he chooses to cancel the contract, either using courts or settlements outside the court, he is entitled to restitution, such that both parties are then put back in the position they were before the contract was entered into. But if he has suffered any loss or some damages, he can claim for damages he encountered due to the defect in that contract. Let us look at the factors which render a contract voidable. First of all, duress. Duress is the use of force, coercion, threats or physical violence or psychological pressure, among other things, to get someone to act against their wishes, to perform an act they would not perform, in this case, thereby creating a contract. A contract concluded as a result of duress is not void since there is consent, but it is voidable because the consent has been obtained by improper or unlawful means. A party who complains of duress is entitled to restitution, provided the required elements to prove that there was duress are present. The requirements to prove that duress was there are: the contract was entered into as a result of actual violence or reasonable fear. The fear was caused by the threat of evil to the party or his family. It was a threat which was inevitable. The threat or the intimidation was contrary to accepted standards of morality, and the moral pressure caused damage to the affected party. So the remedies available in the case of duress are cancellation of a contract, restitution, and damages. Let us look at the requirements in detail. The contract was entered into as a result of actual violence or reasonable fear. Threat must carry weight and must be firm. It must be difficult to overcome. The fear should have been caused by the threat or some considerable evil to the party or his family. The fear must cause a family some serious evil, for example, death, serious body injury, rape, and the person who is threatening must have acted on the threat to make the other party enter into that contract. For instance, in this case, Broodryk was forced under a threat of imprisonment to enroll into the military service by the government officials. He enrolled in that military. Then he sued afterwards. It was held that fear of imprisonment was enough to justify duress, and contract was therefore void. Then the other requirement is that the threat should be of inevitable evil. The evil threatened must be so near that the victim of the threat cannot protect himself against it. It cannot be prevented other than agreeing to the contract. For instance, in this case, Michelle was stranded. Wind was rising whilst she was near the beach. She needed help, which was on a condition of a contract being signed to pay the captain £2,000. She refused, but later, under duress, signed and was helped. It was held that agreement was signed under duress, therefore it was void. But £100 was awarded to the sailor for the services they offered. Then the threat or intimidation should be contrary to accepted standard of morality. For instance, a policeman who used the threat of arrest to induce a contract, this is truly illegal. And looking at this case again, that of Broodryk versus Smurts, the threatening of one and forcing one to enter into the military under the threat of imprisonment was really against the standards of morality. Then lastly, the threat should have caused some damage. The threat must actually have caused party involved to sign the contract, of which he would not have signed if he had not been threatened. The other factor is undue influence. Undue influence occurs when an individual is able to persuade another's decision due to the relationship between the two parties, the weaker party being influenced to enter into a contract against his will. There should be a special relationship between the parties involved, and one party happens to dominate the other somehow, and the dominant party takes advantage of his dominance to induce a contract. For instance, master and servant, parent and child relationship, lecturer and student, or doctor and patient. So we are saying that one person obtains an influence over another, which weakens the latter's power of resistance and renders his will pliable. And such a person then uses this influence in a manner to persuade the other to agree to a transaction or contract which he would not have entered into with his free will. For instance, in this case, Jordan, a farm owner, was sick, and his doctor and children influenced him to give and transfer farms to them while he was weak and very sick. It was held that Jordan's farms were to be returned to him by the doctor, son and daughter, because this was truly undue influence. The requirements that should be proved for there to be undue influence are that the party exercised an influence over the other. The influence weakened his part of resistance and made his will pliable. the other party exercised this influence so as to induce a contract which will, under free will, would never be concluded. The remedies available are that of rescission, that is cancellation, restitution, and also damages, if there are any. Let us look at mistake. Mistake in a contract law is an incorrect understanding by one or more parties to a contract regarding the terms of that contract. There is some error or a wrong impression of the actual fact by one or both parties. So from this we deduce the types of mistakes we have. First of all, we have the unilateral mistake, that is a mistake from one party, or common mistake, that is all the parties are mistaken. A unilateral mistake occurs when only one party is mistaken as to the subject matter or the terms contained in the contract. So, it's a belief held by one of the parties and not shared between them. The general rule is that when one party is under unilateral mistake, he cannot set the contract aside on the grounds of mistake unless the mistake is reasonably justifiable. For instance, in this case, Bulawayo College invited people with 5 ordinary level subjects to apply and be admitted to a cookery course at the college. An applicant with 5 ordinary level subjects applied and the college took that student. Mistakenly, the college intended to expel her and she sued afterwards. It was held that unilateral mistake was not reasonable and justifiable. Therefore, the contract could not be cancelled. We also have common mistake. This exists where both parties are mistaken. They would be thinking that they have agreed when in actual fact there is a common mistake on either side. So, a contract is therefore void as parties are not in ad idem, that is, in agreement. They are not of the same mind. The requirements for common mistake are: the mistake should be one of fact, it should contain a material fact, and it should be a reasonable mistake, and the party setting up the mistake should not be stopped from doing so. The mistake should be one of fact and not of law, which is applicable on the agreement they have in the contract. Otherwise, ignorance of law is no excuse. For instance, in this case, Benning paid £5 custom duty for his machine, thinking that it was supposed to pay duty. He later sued when he heard the machine was exempted from duty. It was held that Benning could not recover the payment he had made because he had a mistake of law. The mistake must contain a material fact, that is, a major or essential fact, for which if a party had known, would have never entered into that contract. For instance, error in negotiation, that is, mistake as to the nature of agreement, when one part thinks it's a contract of sale when the other thinks it's a donation. For instance, in this case, Dobbs used Verran's car without payment discussed. When Dobbs sued for $30 medical bill, Verran said he owed just £15, as some of the money was for transport service he rendered earlier. It was held that there was no contract due to lack of ad idem. Mistake as to the nature of the agreement was present, as Dobbs did not know he had to pay for the transport given. Then another example is error in corpora, or mistake as to identity of the subject matter, where one party at an auction sale thinks he has bought two articles placed one on top of the other, but the seller thinks he has sold one of them only. For instance, in this case, Maritz at an auction saw a mirror on top of a mantelpiece and thought he had bought both items when he paid for the mantelpiece only. So he refused to take the mantelpiece without the mirror. It was held that there was no valid contract as parties were mistaken. Then error in persona, that is mistake as to the identity of a party. For instance, in this case, Beyers was misled by Holmes to think that he was acting on behalf of the government, that is Cape government, and bought horses which he later sold to McKenzie, a third party. Beyers sued. It was held that Beyers intended to contract with Cape government. The contract, therefore, was void due to the mistake as to identity of a party. Then we have error in quantity, where one party thinks that he is going to get a larger sum of money or a greater quantity of commodities than those agreed in the contract. Then number 5, we have error in material or substantia, that is mistake as to the characteristics or quality of the subject matter of the contract. So this error of mistake of the quality or subject matter of the contract is important when the subject matter is a material fact or term in the contract. Otherwise, it is usually incidental and non-essential. Those are situations where a common mistake is said to be material. Let us look at the other requirements for a common mistake. It must be a reasonable mistake, such that an ordinary person would have made the same mistake under the same circumstances. The last one is the party setting up the mistake must not be stopped from doing so. For instance, in this case, Smith showed Hughes a sample of green oats which he bought but later sued, saying that he wanted old oats, not green oats, for his horses. It was held that there was no mistake of minds, as Hughes had seen the green oats he was going to buy and he paid for those green oats. So the contract was there. The other factor which render a contract voidable is misrepresentation. Misrepresentation is a false statement of fact made by one party to the other before or at the time of contracting. It may be made expressly by the use of words or impliedly by conduct. Even silence may constitute to misrepresentation where there is a duty to speak. So we have different forms of misrepresentation. First, we have fraudulent misrepresentation, which is a false statement made willingly and dishonestly with the intention to deceive the other party to enter into a contract. It is a delict, so the remedies usually are damages, then rescission of a contract and also damages. If one treats the contract as binding, he can only claim for damages or for loss suffered. The second form of misrepresentation is negligent misrepresentation. There should be a misrepresentation of fact in this case, which is made by words or by conduct by a party or his agent acting negligently. The other party must actually be deceived by the negligent misrepresentation made. The remedies are available are rescission of a contract and damages. Or the plaintiff may abide by the contract and claim for a reduction in purchase price of a thing sold, that is in the law of purchase and sale. The other form of misrepresentation is innocent misrepresentation, which are statements that are made innocently under honest belief of their truth, but which turns out to be false. And under the remedies, there are no damages in this case. One can only claim for rescission of a contract and restitution. So this is done to restore the parties in their original position as though nothing had happened. The requirements for misrepresentation. The representation was made by one party or his agent to the other in order to induce a contract. The representation should be material, and the intention should be false in fact. The other party should have entered into the contract on the faith of the representation. So let us look at these requirements in detail. Firstly, the representation was made with the intention of inducing a contract. For instance, a minor pretending to be an adult so as to induce a contract. Silence also can constitute to misrepresentation where there is a duty to disclose or to speak out. For instance, in those contracts with oberima fide, that is utmost good faith, like partnership, insurance, or in the purchase and sale contracts where there is latent defect warranties. So silence is usually grouped into active concealment, designed concealment, and simple non-disclosure. For instance, in this case, Glaston House bought an old building from Inag, not knowing that part of it was declared a national monument. Inag knew and was silent. It was held that the fact that the building was declared a monument was a latent defect which Inag had concealed. Inag had to pay for the expenses incurred by Glaston House. Next, the representation must be material. A material representation is one which is likely to influence a person to agree to a contract. The general rule is that if the representation that induces a contract does not come from one of the parties but from an independent third party, it will have no effect upon the contract unless the person is an agent. For instance, in this case, Bird sued Murphy when he bought a Mercedes-Benz from him, stating that it was not the model he wanted, but Bird had taken a drive and really liked the car before buying. It was held that model was immaterial in this case, as Bird had taken a drive and liked the car before purchasing it. Then the representation must be false in fact. It should be false in fact, but statements of fact must clearly be distinguished from expressions of opinion and mayhaps, the following do not amount to misrepresentation. A mayhap, that is, claims by advertisers. A mere statement of opinion. For instance, in this case, Smith sued Van Heerden, saying profits of a bakery he bought were inflated, for which the bakery showed loss actually after he had purchased it. It was held that statements on profit were mere opinions and not statements of truth. Therefore, contract could not be cancelled under these grounds. Then, the other requirement for misrepresentation is that the other party entered into the contract on the faith of the representation. The misrepresentation must have actually deceived the other party to enter into the contract. The party who seeks relief must establish that on the balance of probabilities, he would not have entered into that contract. If the false statement did not in fact induce the contract, the person whom the representation was made cannot set the contract aside. For instance, in this case, Nourse had a flash advert of his farm he was selling, which was exaggerated and had false statements to lure buyers. Poole and Mclennan went and stayed at the farm for 3 days. They saw the farm and true facts were communicated to them. After they bought the farm, they then sued, saying they were misled by the advert. It was held that contract was not voidable, it was really valid, as Poole and Mclennan had the true facts before purchasing that farm when they stayed for 3 days at the farm. That was all I had for you. Let us look at the questions. Distinguish between void and voidable contracts, giving examples for each. What are voidable contracts? A contract can be avoided on the grounds of duress. What is duress? Explain the requirements for avoiding a contract on this ground. Explain each of the following: mistake, misrepresentation. Explain the requirements for the voiding of a contract on the grounds of duress. Analyze the circumstances under which a contract would be set aside on the grounds of misrepresentation. What are the effects of mistake in a contract? Thank you so much for watching. Remember to subscribe, like and comment.